have in our firm is that God is in detail. So it's not devil in detail, it's God in detail. So we believe that we need to, it's very, very important for us as a firm to do our work so well, and then we would like to have we would like our clients to tell us that yes, we did do the small things very well. So that is where, but yes, we are proud about every single work that we do, and so yeah.
Great, sir. Thank you so much. So we are also live on YouTube. Those of you who want to ask questions, we had to disable the chat because of Zoom bombing. I'm sure all of you know about Zoom bombing. There are random people who join the session and then disturb the session. So we had to switch off our chats, and we had to switch off the ability for you to unmute your mics or share your screen. But what we have done is that we have gone live on YouTube, where you can go and post your questions. So if you want to post any questions, simply head to YouTube, look for LawSikho channel, LAWSIKHO LawSikho channel, and you will find this session live happening over there. And there's a live chat function right there. You can post any questions you have live on YouTube chat, and we will take those questions. Okay. So that's about questions. You have any questions, you can start introducing yourself over there. That's very much a part of this discussion. You can go there and you can introduce yourself, who you are, what you want to take from this session, what are your questions, what you do. Just share about yourself in the chat, so I will know who is attending the session, and I can ask the right questions and make sure that you go back with the right value. Okay, so that will be fantastic. So thank you very much. First of all, sir, basic question. A lot of lawyers are worried about that, what will happen to us. This thing, if the courts remain shut, and then clients are also badly affected. Many clients are struggling. So what happens to us? Like, is there enough work for lawyers in this situation? Or is how can lawyers survive, or, even manage to thrive in this environment? What are your thoughts on that? So this is not a technical question, a basic question. Yeah.
Lawyers are going to have plenty of work after this. Once the courts are back into its normal function. In any case, as of now, I think all courts and tribunal are saying emergency matters are okay. But it is just question. But I think what I do understand is that the NIC is now enabling video conferencing facilities for these urgent matters, and then I'm only seeing it as a question of time if this lockdown were to get extended slowly, or even if there is a phased out exit from the lockdown. Even if there's going to be only hearings through video conferencing, I think it's going to be work. There's going to be work for all of us. So, and if you traditionally see, lawyers don't see recession.
Right. So even if clients are in trouble, you still have enough work coming in. Maybe a different kind of work than what you have been already doing, but there is work.
Yes, it may only be a necessity for reskilling yourself, and I think lawyers are very, very adept in reskilling themselves very fast. If there's one profession who get reskilled very fast, it's the profession of lawyers.
Because lawyers are always having to learn new things on the go anyway.
Yes, exactly.
Your clients always come up with completely new challenges, and your success depends on solving that. Yes. So this is no different situation right now. So you just have to learn.
All of us are in familiar territory, I would say.
Okay, great, perfect. Sir, diving straight into today's discussion, what is force majeure and why should we talk about it? I know this is also one of those things that lawyers need to reskill about, reskill themselves in. Like, we had seen this thing force majeure when, in some contracts, sometimes you didn't pay attention. Sometimes when you're in law school, there may have been some sections we are all brushing up our contract.
I agree with you there. I think it's not about reskilling. It's a question of probably getting back to your first year or second year law book, and then a student, when you were a student, you just pick up those. It's just that trying to refresh your memory from there. So force majeure, as I think all lawyers would know well, first thing first, force majeure is not a common law concept. It's a civil law concept. If you really look at it, this is a concept which got pulled into the common law countries or common law contracts from Code Napoleon, which I understand was written way back in 1804. So it's in French. It's a French document. Code Napoleon is a French document. That's a civil law for France then, and that is where it started. And it literally means in French, it literally means superior force. Now, somebody would then say, is that then act of God? No, that's a different question altogether. I'll answer it later. But force majeure would mean a superior force. And what happens is that now, if I were to all of us as lawyers, we would love to refer to a dictionary first, or which is probably a law dictionary, maybe a Black's Law dictionary. Black's Law dictionary would say that a force majeure is an event or effect that can neither be anticipated nor controlled. So that is what that's a force majeure is a legal meaning for it is an event that a party does not anticipate or does not control it. So that is where this force majeure as a concept originated, and that is the immediate one-line meaning for force majeure.
Okay, sir. So, what is the relevance of force majeure today? Is it, what can be called force majeure, and can we, what is this status under Indian law, Indian contract law, or even in other way?
Okay. See, Indian contract law, and see, because force majeure is a codified concept in the civil law countries. It is a codified concept in France, it's a codified concept in Germany and many other this thing where the Contract Act does contain specific provisions for it. But as I said, there is no doctrine of force majeure in an Indian in Indian law, or if there is no provision for force majeure in the Contract Act as such. Because if you look at it, even in England, this provision seems to have got incorporated in the later part of the 19th century. So if you look, that is even our Contract Act is a piece of 19th century document, 1872 document. That looks like force majeure has got into English contracts after even our Contract Act has got codified. Because one of the earliest cases where in England the courts were called to decide on force majeure was sometime way back in 1904. That is one of the earliest, and there was another sometime in 1915. So this is the time when that is there. So as such, you don't have a concept of force majeure in our this thing. But what happens is that it is more because over a period of time, as all of us know as lawyers, India, as a common law country, customs and usage have a very, very predominant significance in our interpretation of law. So by usage of this word force majeure in our contracts, it has actually, if you look at it, it has become a very convenient term. I would say a convenient term to refer to clauses in an agreement which are incorporated to relieve a party from performance of his contractual obligations. That is where, and when do you relieve the party from performance of his contractual obligation is when the performance of that party is impacted by events that are outside his control. Right? So, which means that a natural disaster or a war, or then all of us want to believe even COVID-19 is a force majeure. So this is where, but from a pure legal perspective, force majeure is more governed by the contract document rather than the statute.
Got it, sir. So, now what happens? Like, so many contracts are not, some contracts have force majeure clauses. So what happens to them?
Okay. Yeah.
And what happens if you don't have the force majeure clause?
Okay. Now, see, one thing is if you do not have a force majeure clause, now here what happens is that the fallback option is to the statute book. The statute book has something called as, all of us know, is section 56, which is contracts that become impossible to perform. Right? Now, one has to see whether this contract that I have with my counterparty is becoming impossible of performance. So, section 56 would come into play, where this impossibility is also called as doctrine of frustration. Now, if all of us would remember one case that we had read as a student, where there was this particular person who had engaged the opera house on for his performance, and thereafter what happened was that before his performance date, the opera house got damaged by fire. Now, moment this happened, this person was obviously not able to perform, and then he had moved the court for specific performance. But the court said that, hey, look, the subject matter of the contract is not there. So it's impossible to perform the contract. So thereby there is a frustration to it. And as such, you cannot, there cannot be specific performance granted. Now, so if you look at it, this is what is section 56 really has incorporated the doctrine of frustration into section 56 incorporates the doctrine of frustration. So if your contract is impossible of performance, then yes, you are in a position to take benefit of it, right? Having said that, there's a very interesting decision which happened just as I think on 30th or 31st of March in Bombay High Court, was where the Future Group had moved the Bombay High Court, and yesterday, in fact, it was heard at the Supreme Court also, where the Future Group had moved the Bombay High Court, wherein the Bombay High Court, because the Future Group had pledged their share, some of the shares to IDBI trustees, or I think they had borrowed from UBS Group, and there was a pledge, and then the price, because of COVID and the impact on the market, on the economy, the market started to fall. All of us know how much the stock market has fallen to 20%, 25 to 30% has been the fall over the last 3 weeks. Now, because of this fall, the price of the shares that were pledged by the Future Group were getting affected. So the trustees, which was IDBI trustees who were holding it for UBS, they wanted to sell the shares in the market. Future Group reached out, approached the Bombay High Court, and Bombay High Court restrained the trustees and also the lenders from realizing their security. If you look at it, I understand that there was no force majeure clause in that agreement. And right. Despite that, the court has thought it fit to intervene in this kind of a situation. In fact, yesterday the Supreme Court declined to interfere in that matter. So if you look at it, no force majeure clause, still the court offered protection. So there is, all of us know our Indian courts it's a very, very progressive court. So even if there's no force majeure clause, yes, we may in a deserving case, courts I'm sure would step in and support the affected party.
Right. I think right now the focus of public policy and naturally of the courts in a way is to in preserving businesses and not create more troubles for them in a way that people will lose jobs and everything will be, the economy will be disrupted.
You're very right. You're very right. In fact, the indication to that came from the government also, because if you recall, there was an amendment which was made to the Insolvency and Bankruptcy Code, wherein the amount that one can, the default amount that an operational creditor can use in order to approach NCLT was rupees 1 lakh. That was straight away taken to 1 crore by government by a notification. And so that, as you rightly pointed out, it is preservation of businesses and not bankruptcies. And in fact, I think yesterday is a move by RBI was also a step towards that, in order to make businesses or banks and NBFCs lend to businesses, because I think my understanding is that the interest rates to the bank by RBI is something as low as 4.5 or 4.75%.
Right.
So NBFCs can borrow from RBI, or effectively NABARD and all of them are all being given funds by RBI at as low rate as 4.75, 4.5 or 4.75%. So preservation of businesses is the government's focus today.
Right. And basically in this circumstances, the focus of the banks, NBFCs and any kind of creditors and people who are not getting their dues would be to go and negotiate rather than take people to court and liquidate assets, etc. is the situation. Like people are being forced to renegotiate contracts.
Very true. One is, yes, renegotiate your contract, renegotiate your deal. Take the help of the lawyers who can help you out, who are all trained in negotiating. Take their help and negotiate, so that in the process everybody gets benefited.
Excellent. So we have a lot of questions already have started coming in. There are some basic questions that we want to take even before that. One thing is about act of God, and act of God and force majeure you mentioned earlier, but if you could specifically tell us what is the specific difference.
Okay.
What if I have act of God written in my contract but not force majeure? Then what happens?
Okay. Now I would just want to go back a bit, and in fact want to cite a decision of one of the English decision, which was also referred to in a Supreme Court decision. See, what had happened was that there was this Romanian a person from Romania who had entered into a contract with a UK company. And this UK company, there was a contract for the purpose of building of a steamer, and they were to deliver the steamer in X number of days. And the contract said that being accepted only by the cause of force majeure. This was the only term that was used for force majeure. Unlike today, we will all lawyers here on this call will agree that we put a force majeure clause which has about 3 or 4 paragraphs long, but the only provision which was there in this particular contract was the only word was force majeure, accepted by reasons of force majeure. And so there was a delay by this UK company to deliver the steamer, because there was a strike in UK which for more than a month, and plus of course there was a breakdown of machinery. Now when the English court, when this UK company claimed force majeure for for these events, and then there were a few other events which included its workers having to go and witness a football match. The workers had to go and attend the funeral of the shipyard manager and all. So all these 4 events they claimed as force majeure because it was beyond their control. Because they said that this is beyond the control. But the defense for which was that the defense said no, this force majeure is nothing but a French equivalent of act of God or the Latin equivalent of vis major. Now here the King's Bench said that one has to necessarily impart a meaning to force majeure which is more extensive than the act of God or vis major. But it said that to what extent it must be more extensive is difficult to say, but they recognize that it is important to make it more extensive. It's not a limited term, or it's not as limited as act of God. It is much more extensive than your act of God or force majeure. Now, in fact, subsequently, the Supreme Court in 1961 decision, it referred to this particular provision in the this particular decision of this thing. I think this 1961 decision was Dandrajmal Govindram versus somebody. I don't recall this thing. So it said that one has to see that is force. They interpreted force majeure. They said yes, it is not equivalent to vis major or act of God. They said that events it has to. There are certain events which has to something like a strike or even if it is not covered in the force majeure language, then it or even a breakdown of machinery can be construed to be force majeure. And they said that the intention of force majeure is to save the performing party from the consequences of something over which they do not have control. And they said one has to give the widest possible meaning to this. So that is how the force majeure is not equal to vis major or act of God.
Great, sir. So when we have a force majeure clause in the contract, how does it actually help me? If I have it and all this situation has happened and I'm in a difficult position, either I don't want to, not able to perform a service or not able to pay. So what happens?
See, what happens? See, now, as I said that force majeure, what is the language that is employed in force majeure is what is going to determine the extent to which you are going to be saved from your performance. Right? So it is what is, so whether if now this instance where I cited about this UK decision, as I said, the only word which was there was force majeure, nothing else. Because today, if you look at it, all of us put a structure to a detailed structure to a force majeure. Now, when we bring in a structure to force majeure, what we do is that we say that, okay, we define what is a force majeure event. We say, okay, now we list out the certain events which are construed, which are to be construed to be force majeure, like war, strike, and earthquake, and all those things. And plus, we also do a catch-all phrase, which will say that something that is beyond the control of the party, which is not foreseeable, and which is probably not mitigatable. Right? So, moment we bring in that kind of a language there. Now, to what extent you are going to be as detailed the language is good for you to have in the contract. Reason is that you will, in effect, it'll say, because it will cover as many situations as possible. You have a very small one, then it becomes more to do with how your what is the language that you have in the document, which is what will come to your head. Because as I said, the impossibility of performance is what is contained in the legislation. But if your force majeure clause needs to help you, it is you need to have a good one, a watertight one.
So what is the common mistake that people make while drafting their clauses?
Okay, what we have normally seen is that the first thing is what people do is that, see, let me put it this way. I would say what constitutes a good force majeure clause.
Okay.
Right? And then afterwards we'll address the second part. So what constitutes a good force majeure clause is that define the force majeure event. Once you define a force majeure event, make it as exhaustive as possible, and also, yes, all of us may always make it an inclusive one, and do not do an exhaustive one, right? When you define the force majeure event, right? And also say that whoever is the party who wants to take benefit of the force majeure, he needs to have two things. One is he needs to have an obligation to mitigate, and he should have the burden of proof to show that it is a force majeure, right? So, moment you bring in this two obligations on the party wanting to claim relief under force majeure, you will then what will happen is, moment you have the burden of proof and the obligation to mitigate, now correspondingly what the natural consequence of that is that there is a duty, you create a duty on him to report it to the counterparty. So you make this, so when I have a burden of proof to show that I'm relying on force majeure for me to get myself saved from the contract, or if I'm wanting to get a benefit, I need to report to the counterparty and say, hey, look, I am constrained by a force majeure event, and I need to have a respite in the performance of my obligation. Now, plus in addition, the last part is that you should also specify what is the consequence of a force majeure event. Now, for example, if you look at it, just about, I think, within a week, all of you at Delhi had an earthquake. Now, good for us, it was not something which was major. Now, like we have seen many places where there have been earthquakes. Now, the earthquake affects only that particular place, but it may not affect the counterparty. Now, in that kind of a situation, the counterparty should have the ability to terminate the contract in case the cure for after the force majeure is not done, or if the obligation does not restart within a particular specified period in the contract. So you will have to specify the period for which one of the parties can wait. Thereafter, you should, in a position, the counterparty should be free to not be bound by it. So that is an option that we there. But at the same time, okay, that is for the counterparty. Now, for the party who is claiming benefit under the force majeure, you should also specify what is the right that he should have when he is doing that. So it could be something as simple as having to his ability. There could be a deferment in his ability to perform his obligation, or it could also be that where he can also, it depends upon the counterparty whether if he wants to have a ability to terminate the contract or not. So this is what constitutes a good force majeure clause. And mostly, if you're able to follow this structure, then yes, you are in. Well, like this force majeure clause can be written in as simple as, say, a 5 to 6 lines in a document to a 3 to 4 paragraph this thing. So it is, again, it depends upon how much our English permits at, or given that situation in the contract, how much you want to write. Based on that, you can structure it, but please cover all these points.
Yeah, I'm sure going forward, people won't look at this clause as just a boilerplate and will have to think this through, because given our experience, clients will also expect, like, you pay special attention to the force majeure clause. Now, let's say you have a good force.
Since you mentioned on boilerplate, I'll just tell you,
Uh-huh.
the Encyclopedia of Forms and Precedents,
Mhm.
right, published by Butterworth,
Mhm.
on force measure has 20 formats.
Right, right.
So boilerplate is available is 20.
Wow. Okay. Yeah. So, sir, if we have we have the right clause and it covers our situation. One thing is that what would cover our situation? Would, like, for example, this COVID-19 situation. Of course, like you said, the way depends on the way it is drafted. But let's say it is covered, and now what happens? Anyway, courts are very liberal to interpret as even whatever you have drafted. Now the situation is, it looks like that courts might take it against you and allow you to claim force measure. But how to do it right? Because it cannot be that I just say, oh, it's force measure and don't do anything, and later when the time of payment or time of delivery comes, I say, hey, I'm not delivering it, or without any information. So how to invoke this force measure correctly?
Okay, excellent. It's a good question. See, in the sense that irrespective of what level of detailing your force measure clause has, it's always important, as all of us know, to act in good faith, right? So acting in good faith would mean that I notify my counterparty about the force measure. Now, one can always say, hey, look, all of us know COVID-19 is already there. What is there for me to notify? Now, yes, that's a good argument. But at the same time, but as I said, it is more when I see it in the action relating to acting in good faith, then I would say that please, even if you have not notified so far, it's not late. Even now, go and intimate your counterparty on force measure based on how your this thing is drafted. Now, there also, now if you look at it, in most cases, in many contracts, all of us make a detailed provision for a notice clause. We will say no, for notice to parties have to be given in the following way, right? So when we say that, now it is possible that the most of those notice clause will say that I would have to give notice by way of a post or a speed post or a courier. Today, I think all of us we don't incorporate fax as a concept in the notice clause. But most of us, what we don't do is that we don't include email as a method of service. Most contracts don't have it. Even, and you will say that, okay, post offices are not working. It's only going to be working only from 20th. Courier is also going to work only from the 20th. Even then, if you're able to send it by email, okay, 20th is just another 2 days away. Send it by post courier, or even if you want to send it today or tomorrow, send it by email. So that is right. But having said that, is court going to be looking at it everything liberally? I doubt it. Yes, courts are going to look at it liberally, but one thing that we need to remember very much, when force measure will not come to your help, is if you are negligent or if there is misfeasance by you. If negligence of a party cannot be a good excuse for force measure. It cannot be this thing reason. If the misfeasance by a party cannot be a good excuse for force measure. So act in good faith. Ensure that there is no negligence on your part. And yes, if you're able to give notice, give your notice.
So that also brings about the question of mitigation, because if you have given notice, etc., fine, but the question is that, do you have a duty to mitigate, which is, maybe you can explain the concept, because if I could do something to help out my counterparty or minimize these damages or losses and I didn't do it, then can I still claim force majeure, or what happens?
Yes. Okay. See, in a mitigation concept, let me put it this way. Now, let's go back. I would maybe want to draw reference to the Home Ministry's notification on the day of lockdown. I think it was on the 24th or something. Right? So what it said was, as much as possible, work from home, right? And so in that situation, say, take for example a company which is in an information technology.
Right.
Now, if you're in an information technology company, for you working from home is possible.
Right.
Right? So, and even there, so moment you do that, so which means that you are still expected to continue your work. You cannot stop work. In fact, some of my clients, in fact, just when the lockdown, between that Sunday of the Janta curfew and the day the lockdown happened, their admin department shipped out from their office desktops to their employee residences and rooms where they were living. The reason is they wanted their employees to continue working on the projects being based at home. So this is what is an example of duty to mitigate. Yes, your teams may not be in a position to deliver the services or deliver your product in the same efficiency as they were doing it before. But you would still be there could be a delay in the delivery, but still you are in a position to reduce the delay. So that is where that is what is the concept of duty to mitigate.
Right. Now, let me ask about a more problematic situation. So, for example, there are the chairman of CIPLA gave an interview, and he said that they are essential service and they were allowed to function. Right, they were not required to shut down their medicine factories.
Sorry, I'm losing you, Ramanuj.
Am I audible now?
Yes. I'm
saying that the chairman of CIPLA gave an interview, and he said that although you're an essential service, right, but where do I'm not able to get my laborers to come to the factory to run things. I can't get my employees to come and run the factory, the medicine factory anymore. I understand we really badly need medicines, etc., but people haven't been coming. And also, how will they come? There is no they don't have any transport. People are coming from a distance, and and the company cannot arrange for transport so quickly. So this was an interview. Now this is a situation where government has allowed you to function, so to speak, but you are not able to function, although in theoretically it is possible to do it. So how do you think that gets impacted? Like, let's say they have a a delivery agreement and they fail to deliver. How will courts view it, or how will that be impacted by say, even from this mitigation point of view?
Got it. See,
because parties will always come and say, why didn't you arrange for transport? Why didn't you house them inside the factory, etc., etc. There will be many arguments.
This is where the burden of proof steps in. What I was mentioning to you before. So now it is for you to, and the burden of proof and the good faith. Now you will have to demonstrate what are the efforts that you had taken and what are all those steps that you had taken in order to mitigate the entire situation. So that is where now it has becomes very important. So tomorrow when you are being sued for a purpose of non-compliance or non-performance of your obligations, now you will have to demonstrate. There is a while now the courts look at certain concepts while they interpret, or when they look at the force majeure events. So there is something called as a causation test and also the but-for test. So here it would be when you look at it, probably but for this, how would it have happened? So this is where the burden of proof and the good faith actions will step in. And but yes, it's a very, very practical situation where with migrant laborers having got dislocated due to this, it's a very, very critical situation where people are companies are unable to find employees. In fact, let me give you an example. When day before yesterday, when the Home Ministry circular came in, soon after about permitting companies in industrial estates to start their manufacturing activities. So I had immediately intimated a client of mine who is into the paint industry. Now, they are in an industrial estate. Now, today morning, he calls me and says, I am trying to get hold of people to come back to work, but I'm not sure whether I will be able to start opening on Monday. That is a practical situation. We'll have to deal with it. I'm sure courts are going to be very liberal. But here I will have to mention one thing, Ramanuj.
Yeah.
Is there are two countries which I have so far come across. One is Germany and other one is Singapore. They have come up with a very, very separate legislation to deal with issues that arise out of COVID. Right? Multiple things, like I think so many issues that can always happen. I only hope our parliament also does that, so that in a sense that it would, while lawyers have work only when there is litigation, but at the same time, it is also important that there is harmony in the society as a whole. So to that extent, one has to look at a legislation of this nature, which will resolve multiple issues that arise out of COVID.
Right, sir. So, another question that comes in, okay, if I don't have a force majeure contract, then to what extent we can claim frustration? I think what you said answers even that to a great extent, but if you want to add anything.
Sorry, what is the last part of it? To what extent?
I was saying that even whatever you said about force majeure and how courts may interpret in the future, given the practical difficulties, even in terms of frustration, I guess the same standards more or less will be applying.
Correct. See, so far, given the hindsight of the precedents that are there in frustration, courts have looked at every frustration is not an impossibility, right? For example, in a sense that, see, if you look at it, there was a 2017 judgment of the Supreme Court in Energy Watchdog versus CERC, where the Supreme Court said because there was a increase in price, which made it difficult for the party to perform. So the court said that, hey, look, it cannot. This is while there is a difficulty, it is making it onerous, but at the same time, it cannot be an event of force majeure. So increase in prices of raw materials or your inability to pay is not a force majeure. So that is the thing. But again, going on this particular thing, it's also possible that our courts may bring in evolve a jurisprudence relating to maybe a doctrine of partial frustration. It's possible. If you look at it, this is again a partial frustration is a concept in the civil law country. It is not very evolved either in India or even in English courts, but it's possible. So because I think our courts are very progressive, so it's and they are only but our courts are very, very strong on fairness and equity. Right? So they are surely going to look at whether there is fairness, there is equity, and maybe the jurisprudence may evolve, look at fairness, equity vis-a-vis COVID-19 situation, and probably evolve a particular new principle.
Right. So just to clarify, it is the burden of proof will be on the person who claims frustration or claims force majeure, right? Not on the other side.
The burden of proof is, a burden of proof is always on the
person who's invoking something.
Invoking the force majeure.
Right. But after that, they'll have to also go on to show mitigation, etc.
Absolutely.
Right. So that would be quite a bit of challenge in many cases, and lots of work for litigators. Right. So
it is no, that is where I'm saying I think there are quite a few of us who are working with the government to see if we can evolve a legislation either on the lines of the German law or the Singapore law, because Singapore law is a common law country, right? How a common law country can also legislate a COVID-19 situation.
Right. And many people have asked questions about this. I think I'm going to turn. There are two specific situations that I want to ask you specifically about, and some people have asked questions also about that. One is what's going to happen to rent agreements, and what's going to happen to employment agreements, because these are things that are affecting a lot of people. So can employers say that because of force majeure, etc., frustration, I'm going to give you only a partial salary and not the full one, or I will temporarily lay you off, or I will temporarily not give you salary? What can happen? And same thing for rent. Can people say that I can't pay you rent for the time being, etc.?
I'll first answer the employment and then I'll move on to the rent.
Okay.
In employment, I would categorize two sets of people. Now, one is people who are workmen who will fall within the definition of workmen under any of the labor laws.
Right.
And two, the persons who are in the supervisory function and who all of us would probably want to call as a white collar employees.
People who are not in manufacturing, not workmen. So
no, I would call the blue collar and the white collar.
White collar, sure, okay.
Right. Now, even in manufacturing, you have the blue collars and the white collars.
Right.
Now, what happens is that with respect to people who are blue collar, who are rather workmen defined under any of the enactments, be it the Factories Act or the Workmen's Compensation Act or any of the other. Now, look at it. Now, in the Industrial Disputes Act, the Industrial Disputes Act has a concept of a layoff. And when I do a layoff, I am under law, I am permitted to pay only 50% of salary when there is a layoff. Now, is COVID-19, because of this, I can, as an employer, I am entitled to declare a layoff. The lockout, consequently a layoff. And eligible to pay, there is law has given me that authority. But look at it, what happened? The government gave a advisory under the Epidemic Act, or I think it was under the Epidemic Act, or I think it was under the Disaster Management Act.
National Disaster Management Act.
It's under the Disaster Management Act. I think they invoked Section 10L or something like that. So under that, they said that, and then to what extent, as a lawyer, I know for sure I have a very good case to defend a client who is going to, who's paid only 50, who has declared a layoff and then done it. But look at it the other way. We were talking about fairness, equity, how courts will look at this. Now, will a court, given COVID-19, and wouldn't court look at equity, humanitarian angle, and say, for a workman, what you have done is incorrect? So I would feel that the court was then in that kind of a situation is going to favor the workman. And it's very difficult, while all of us maybe theoretically be strong on our point of law under the Industrial Disputes Act, but it's not going to, the courts are not, I don't think courts are going to favor the employer, they are only going to favor the workman. Contrary to it, the white collar. Go to the white collar. Now here what will happen is that there are some employers who have a force majeure clause in their employment contract with these white collar. Or I will give you again, I will go back to an information technology industry as an example. In an information technology industry, all of us would have heard somebody got benched, or he's on the bench, which would mean that he is not associated with any specific project, right? So most contracts of these information technology companies have a provision where if a particular employee is not associated with a project, then during that period, he does not get his full salary. The contract would already provide that he would get 100 minus X percentage of the salary when he's on a bench. So when that particular concept is there, if you are not associated with the project, then they can invoke it, pay it. But there is always this humanitarian angle, which is always there. How courts would see is my guess is, but I would tend to.
No, humanitarian way, this way also goes that, if the employer has to shut down, then everybody loses their job. And so in that way, courts can take that as well. And that's pretty much present also. That is present in the common conscience in India right now, that we must save our businesses. Otherwise, we'll give the job. Right.
Absolutely. In fact, there was one opinion that was given by a firm based out of Delhi to FICCI, which I was privy to, which was shared with me, who had said that if you are incurring loss, you need not pay your employees. And he had given a justification on this line. If you are incurring a loss, then yes, you are also in a position, not in a position to make payment. But it is rather better that you are able to provide employment, you are able to guarantee employment for your people once everything restarts. Right?
Right.
So that is the this thing there.
Yeah, I think, even employees, one good thing is that employees are coming forward and saying, let us save the company rather, or save the business, because then we will have jobs later on. Otherwise, in this market, it's not like one employer doing this, right? If nobody's going to give us jobs otherwise. So
Absolutely.
It's possible to amicably settle this by negotiating with them as well.
Very true. Very true.
This is a good time to do this.
The second part of it was on the leases.
Rental.
Right. I think on leases, there is a decision of the Supreme Court which says that a lease is a concluded contract, and as such, Section 56, which is frustration or impossibility, cannot be invoked. Right? But if your contract if your lease agreement has a force majeure clause, then on the strength of it, you can see what best can be done. So if you are in a position to, if your force majeure clause in your lease agreement does have a provision that in case you are unable to enter the premises for any reason, then yes, then you are saved, and then because of which you need not make payment of your rent, then yes, you are saved there. But look at it in a situation of, say, any of these malls and all of them. Their entire business is dependent upon the opening of the mall. Right? But most of the force majeure clause, I think they are collecting only the maintenance cost and not the
rent.
The rent.
Right. So there are a few people who have asked questions, like they have raised their hands to speak. So let's take some of them. But first, I will take some of the questions from YouTube, where in live chat, many people has asked a lot of questions. So live questions I'll take just in a moment. Let's just take this very quickly. There's a question. Next, this is a question by Yamini Jain. The question is essentially about urgent matters, like where a certain contract was time sensitive, okay, and it had to be performed within a specific period, and that performance was of utmost importance. So if such a contract is frustrated, then what happens? Is there a different treatment, or can I ask for a force majeure exception in such circumstances?
I'm not too sure if I followed that question correctly.
Okay. So I think basically what she's asking is that if there's a time sensitive contract where the performance within a specific time period is important, like critical,
Okay,
right?
where time is of essence
Of
in the
essence,
contract.
correct. Time is of essence. So in such situations, can I still claim frustration?
Okay, if time is of essence, if whether you can claim frustration, if your contract has got frustrated, even if time is of essence, then if the subject matter of the contract is frustrated,
Nothing can be done.
nothing can be done.
Same thing for force majeure, right?
See, in a force measure, in a force measure is always an event that is beyond your control. Right. So
Right.
yes, even if it's of time is of essence, assuming that yes, there is a breakdown of your machinery, or if there is a flood in your factory, even if time is of essence, how you still have to be given allowance because of the force majeure event.
Some people are
That's
asking,
the obligation to mitigate.
right, mitigation is important, right? So there is some question. So there are several people have asked these questions. It's about, what if there is a suspension for a brief period but not frustrated? Like contract, we can't say, the contract was really frustrated, but there had to be a suspension for a certain period. Then what happens?
Okay. See, I think one of the reliefs that are given to a party claiming force majeure event, relief under the force majeure event is a suspension.
Right.
Right. The parties are going to claim a suspension for a brief period. But whether that now, if it's possible that contract may say the period of suspension cannot exceed X number of days. It could be 30 days, 60 days, or 15 days, or whatever. Now, whether is there a consequence of that particular, if the suspension is not if the suspension continues, then what is the relief which is available to the counterparty as per the contract becomes relevant to be seen.
Okay. There's a question about whether force majeure can be claimed with respect to fundamental rights. That is not a constitutional law question. I mean, force majeure is a contract law, performance related thing. But sure, I mean, you want to take this question like, is there a force majeure with respect to our fundamental rights?
I would love to look at the scenario before I respond. I am not able to imagine the situation on the go.
Right, right.
But if
Like,
something is able to, if that person is able to specify where is how it would arise, then it becomes easy for us to think through that.
Sure, sure, sure. So please go ahead. This is a question that was asked uh, I think, I can't find it anymore. Yeah, Aparamaya. Aparamaya, if you want to ask this, you want to specify, happy to take it. This question on usually developers take benefit of force majeure clause for making late delivery of flats. Can buyer of flat make late payment without payment of interest in absence of force majeure clause? Interesting question.
See, any question of the moment we invoke force majeure, then it is governed by the contract document. It is not a force majeure event, is not a statute driven provision. So let's, unlike it's in India and other common law countries, force majeure is a contract driven, is contract driven.
Right, right.
So to what extent your ability as a buyer of the apartment, what is the relief is possible for you under.
And the contract won't have this for the buyer for sure. So what can be done in this situation? Is there any option to delay payments or not pay interest?
Negotiate. Always use. I think this is a very, very, as we spoke first, this is a very, very good situation for all of us to negotiate with the counterparty and take the best possible deal based on the situation.
You said that there are some scenarios where the court is extending force majeure, although like it was not there in the contract. So what happens?
So one that we spoke about on this thing, the future group situation.
Yeah. So how can that help here in any way?
See, we need to look at it. See, I think it's very, it's going to be very, the question is generic, so I'm able to give a very generic answer.
Right.
A specific answer would really require a specific look at the document or the person's situation, based on which we can see what is the solution that we can give it.
Got it. So what's a look? You have to consult a lawyer. This is a tricky situation, not something that off the shelf, hard to decide.
Yes.
There's a question on same question. There's on stopping lease rental payments and all of that. Supreme Court has declared this time will not count under Limitation Act. Of course, sure. We expect can we expect a comprehensive legislation? Hard to say, but the government is looking at it. We understand that the government is seriously looking at it. The Home Ministry is considering.
See, I think it's just a matter of time, probably. If you look at it, even while there could be multiple views on how fast the economic package is coming out and all that, but it's look like it's probably just happening in installments. So it's just a matter of time that all this will happen. It will fall in place, or even the comprehensive legislation will happen soon, is my feeling.
Okay. So the question on, is employer liable to pay contractor for losses sustained during lockdowns? If you have a contract, you're hiring people through contract, then what happens? I think it's the same. The answer doesn't change. It's still governed by contract, right?
You're going to be bound by the provisions of the contract, right? See, if there could be in a contract, could have a provision in terms of change in circumstances, change in scenario, or change in costing. If all those are covered in your contract, then yes, take the best benefit out of it.
Great. Let's just take some of the people who have been raising their hands. Let's just quickly bring them in. Gaurav Ahuja, I'm unmuting you. Gaurav, please speak.
Yeah, hi. Am I audible?
Yes, go ahead. Next will be Swapnil. Okay, so Gaurav, please, your question.
Yeah. So my question is regarding the notice part, which you told that you have to serve a notice if there's a force majeure clause in your contract. And suppose the notice says that you can, the clause says that you can serve the notice only through a speed post. And in today's scenario, if that is not possible, then what will happen? I mean,
where I understand this. See, in fact, speed post, normal post. See, this is where I was saying that it is good faith. Yeah. Send it by email if you have the email ID, and then once the speed post opens, follow it up with the speed post.
So will the law of limitation also apply in this? I mean, mentioned that it would be
limitation is something that becomes applicable more for a situation where the time period, the gap,
cause of action
and the time that you actually commence the action. That is law of limitation.
So
my actually the
suppose how much time do you have to give a notice?
Right. If there's a 30 days time period mentioned in the contract itself, and because of this lockdown you cannot serve a notice through a speed post or maybe through a normal post, then what will happen? My basic specific question is
in good faith. If you have acted in good faith, the court will take it in your favor, right? Courts are taking a lenient view. Nobody will take a.
You will have to see if intimacy. They look at it this way. Given this particular scenario, have I intimated him?
Right,
what
exactly.
The court is going to look at it. And if I have intimated, what is the mode? Do I have proof of intimation?
Right,
so,
exactly.
The moment you have it, moment speed post start operating, do send out that intimation by speed post also.
Yeah. And also the question is about how long. If I have already not given notice, till when can I give?
Right.
Sorry, Ramanuj?
I think he's trying to ask, if I have not, given notice already, how much time do I have to give notice?
It depends upon what is the time specified in your contract. No time specified, ASAP.
Yeah, and if you have not done it ASAP, can it still be done later?
Act in good faith.
Act in good faith, right? Okay, so let's unmute Swapnil. Swapnil, you are live. Please ask the question.
Yes, sir. Good afternoon. I have a question.
Good afternoon, Swapnil. Yes, please.
What date can be considered as the effective date of suspension regarding the obligations of contract? Whether the date of invoking the force majeure in this case, or the lockdown date, that is 12/3.
Okay. Now, it's possible if you see that the national lockdown started, if I'm right, on the 24th or 25th.
Right, sir.
Right. Before that, there have been, if you take, for example, Kerala. Kerala and Maharashtra were one of the earlier states which were curtailing the movement of people. So it's going to be dependent upon that where you are residing, whether you got affected by the national lockdown or this thing. But even before that, if you look at it, the Ministry of Corporate Affairs had recommended, or there was also many the government, I think, they started advocating social distancing, and people even they started advocating work from home.
And sir, not only that, even going back to, there are contracts which are dependent on supplies from China, etc. That has been disrupted for 2 months earlier already.
Absolutely.
So
Absolutely.
yeah, so the question is that, are you disrupted or not? So if you can show that there's a disruption completely and you could not perform, so then it's okay. Then you can claim even earlier.
Yes.
Yeah. Okay.
Yeah.
Okay. So Prashant, I will unmute Prashant.
Yes. Good afternoon, sir.
Good afternoon, Prashant. How are you?
Yes,
Hi, I'm fine. My question is, in a litigation, can I claim, first of all, the force majeure, and after the change of circumstances, can I later on invoke that frustration? In same litigation, in same matter, because I have some project, right? I have invoked by intimating notice force majeure, but after due course of time, circumstances changed, and I want to go for frustration. Can it be done?
Okay, I'm presuming that you have a force majeure clause in your contract.
Yes, yeah.
And so you want to know whether you want to see whether you are saying that can I invoke both the force majeure as well as frustration.
Right.
Dependent upon your case, you are very much entitled to do it. It is going to depend upon the facts and circumstances of your case.
Okay, okay. Got you. Thanks. Yeah.
Great. So after this, let's see, Devansh has a question. Devansh, please speak. Devansh, you're online. Will you ask anything?
So, am I audible?
Yes, you are.
Yes, Devansh, you are.
Good afternoon, sir. My question is specifically regarding the invocation of force majeure clause by the small, medium enterprises and companies, and how they can restructure the business strategy after the post-lockdown.
No, okay. You're saying
You're asking a question about law or about business strategy?
No, like I wanted to, like, if there is no force majeure clause, and how will they go about it, and how they can actually like take the advantage of the force majeure clause?
See, if there is no force majeure clause, then how do you take advantage of it? Only when there is something there, you can take advantage of it. But I think what you are asking is, how do I take advantage of this COVID-19 situation? Is that the question?
Yes, sir. Yes, sir.
Advantage to what effect?
So, like, there's a slow in economy and like people are not able to work, and there is a loss to companies also, and they are not able to perform their contracts. And so, how they will like? Is there any situation? Is there any thing which they can do to mitigate the loss?
I think there's one thing that all of everybody should do in this, whether you have a force majeure clause or not, is negotiate and bring forward a new contract or bring about a new business situation with the party with whom you want to get benefit from.
Okay, okay.
So,
Thank you.
so you will have to necessarily negotiate. So, which would mean that you will have to speak to them. You got to tell them what is your situation. You got to be very open about your situation, how you have got affected, how your business has got affected. Do an act in good faith. You would surely get the benefit of the good faith action always.
Yes.
Excellent, excellent advice. Rajat.
Hi.
Hi,
Hi,
Rajat.
hi, Rajat.
Hi. My question is regarding that COVID. So most of the companies we will see suits getting sued by their employees and shareholders and director versus directors after COVID in terms of failure to disclose or adequately disclose risk that company faced or failure of that company to update prior disclosure or maybe inadequate step to mitigate risk and also failure to develop adequate contingency plans. So what do you suggest how these C-suits, the executives of the company should inform their directors or boards or shareholders in order to tackle these kind of claims?
See, if you're a listed company, this is where this possible situations are likely to happen. So, in under the SEBI's listing obligations and disclosure regulations, so that is which is the SEBI LODR is the abbreviation that acronym that everybody uses. As for SEBI LODR, if there is a material event that has happened based on the and material event is dependent upon the materiality policy that the company has framed for itself. Based on that, if there is a material event that has happened, you are required to intimate the stock exchange. So that is something that you are required to do. So you should have, if there is a material event that has affected your business, if COVID-19 is a material event, as per your materiality policy, then yes, you should have intimated the stock exchange. So that is the dissemination. Moment you intimate to the stock exchange, it would mean that you are disseminating information as to how your business has got impacted. Otherwise, I agree with you. Then there is possibility of of the shareholders or even SEBI may initiate action against the company for non-disclosure of information under the SEBI LOD.
Okay, there's a question from Shamant Satya. Shamant, please go ahead.
Hi, sir. Can you hear me?
Hi, yes, Shamant, I hear you loud and clear.
Actually, as you're considering a situation where a party to a contract without a force majeure clause sues the other party for damages for delay in performance of the contract, which is directly attributable to the pandemic. So in such a scenario, will the court really go ahead and grant damages, or will it take into account that because of the government orders, party was unable to perform the contract, it was unlawful for him to perform the contract, and will it on account of fair play and equity not grant damages?
I would think so. I think our courts are very fair that way. I think courts do know. See, it again depends upon whether you were in an essential commodity industry or not. If had you been in an essential commodity, one of the essential commodity, then in that case, then it's going to be dependent upon the exact situation why you were unable to perform. If you're non-essential, then I'm sure I think equity is surely going to play a role where court know now if the government orders are there on the lockdown and there's no way that somebody could have opened the factory and worked there. So I don't see a reason why the court should award damages for this period.
Yeah, so that means even if you have not done anything regarding force majeure, still you may get benefited anyway.
Yes, I think that's a reasonable. Our courts are always reasonable.
But except that when the other side comes and say, look, they have not done any mitigation, they have not done any good faith actions, then it may be.
See, what is it? See, what is mitigation is going to be dependent upon. If I am a factory, what is the mitigation that I could have done?
Right.
So,
Sure. So we'll go to Deepa. Deepa, please ask your question.
Yeah. Can you hear me?
Go ahead.
Loud and clear.
Okay. Yeah, just one query. In some of our matters, we have like a contractor who has been giving us contract labor. So we paid up till end of March, and then we sent a notice saying that by email that and our contract does have a force majeure clause. So with respect to that, we have gone and given a notice by email, and as you suggested, once Speed Post opens, we will be doing that as well. But in the interim, is an acceptance from the other party necessary, or just a response mail that, okay, can you still keep these people? And I've gone and said, no, we will not be able to. Is that much enough? Or an acceptance important? That, yeah, I accept your terms or things like, is that important?
If it was a contingency contract, then probably yes.
All right.
But again, contingent contracts have its own effect under the contract. So, right. So, but again, see, if you look at it, I think what your question is that I have issued a note. I have a force majeure clause with my contractor who's providing me contract labor. I have invoked force majeure clause saying that I will not going to pay him. And so your question is, should my contractor respond back to me saying that yes, I'm okay with this?
Yeah, is express consent mandatory?
Okay, that's going to be dependent upon your contract, how the force majeure clause is worded. If it's silent, there is no necessity for an acceptance.
It is silent. It says that we will be intimating. The party will intimate.
That's
be communicated. So yeah, so okay, fine. And I'm sorry, just one continuation to this. This is with respect to this particular thing, but otherwise, even in general situations, once I have invoked a force majeure clause, then is express consent per se a mandatory requirement, even if the contract is silent on it?
Sorry, express consent.
An express consent. Mandatory or not, in case the contract is silent on this?
Silent on what?
In case the
contract doesn't say force majeure, and I want to invoke force majeure, then what do I do?
No, Ramanuj, 1 second. The contract does have a force majeure clause. This is I'm taking a hypothetical situation now, that in case the contract does contain a force majeure clause, but it is silent on whether an acceptance is necessary or not, then in that case, what is the situation? Once a party has invoked, then what in case the contract is
if the contract does not say that acceptance by the other party is necessary, then there is no question of acceptance.
Yeah, then you can invoke and the other party has to accept.
By plain
if you have invoked it in bad faith, then he can still sue you. If you're invoking it just to cover up your negligence or your misfeasance,
definitely,
it doesn't save you at all.
True.
See, so long as you have invoked legitimately, you don't have a problem.
Yeah.
All right. Thank you so much.
Thank you.
Naju Matthew.
Very good afternoon, sir.
Yes.
Yes,
sir. Fundamentally, my question revolves around the validity of the contract. So, keeping such epidemic in mind, tomorrow can I cap my limitation of liability, saying that on event of a force majeure, both the parties' liability would be so and so. The cap on the liability. That is one. Second is on the termination clause. whether let's say on the event of these epidemic, can I put a clause saying that the once this event happens, the obligation of the party stand cancel, and further the party can renegotiate? Can I do that?
See, in any case, you are talking about a contract. You are talking about, we are not talking about a concluded contract. You are talking about a future one. Please, I think, see, this is what is the beauty of contract law in a common law country. It allows parties to determine how they want their relationship to be governed, right? And you can do the way you want, and factors outside of the contract do not affect much, except so long as you meet section 10 of the contract.
Right. So unless there is any violation of public policy or another specific statute, you can go ahead and write whatever.
Absolutely. So long as you don't, you are well within, if you are entering into a contract which is not prohibited by law, you are fine.
Yeah, and a lot of contracts have limitation of liability clauses.
Absolutely.
So I am going to do something adventurous right now, sir. So I am not sure. These are usernames that are not of a human being. So let's see if this works. Sai member. I hope this is not Zoom bombing. Can you speak? I have muted Sai member. Somebody called Sai member, the username. You have any questions?
Hello, can you hear me?
Yes, go ahead.
Yeah, okay. So this is actually, first of all, I don't know why I'm called Sai member there.
You have to change your username in Zoom. Okay, go ahead. Ask the question.
So the question basically is with respect to the bank. So banks have entered into a lot of loan agreements with lenders, small-time lenders, with MSMEs, and none of these loan agreements have most of these loan agreements they don't have a force majeure clause. So now as a consequence of what has happened, there is going to be a cascading effect, and the companies are not going to be able to pay employees. Employees are going to get laid off. As a corollary to that, they are not going to be able to pay their EMIs in time, and their assets might get classified as NPA. So can the employees, although there is no force majeure clause, how can these people tackle these events? What are the differences that they can bring before banks and NBFCs in order to be able to defend their non-payment of the loan?
See, I think I think based on the RBI's advisory, all banks have already framed a policy wherein they have said the next 3 months I'm not going to collect your EMIs. And in fact, all the banks, I think in a uniform way, they have said that if you want me to debit your EMI, please intimate me. Right? That is this thing for the next 3 months. That is what is the this thing. So if you want otherwise, if you don't pay your EMI for the next 3 months, the interest for the 3-month period is going to get accumulated. It's going to still be charged, and it will be added to the principal.
And there'll be penalties and everything, right? So all
No,
that.
No, for the
so right now they have made it clear that you don't have to pay interest. It is a deferment. You have to pay. You have to pay interest later on, deferred interest. But
yes,
you do not. Your credit rating doesn't go bad. Nothing happens.
That's right. That's right. And then that too, this interest for this 3-month period is going to add it to the principal. So again, what will happen is, so supposing you have a 1 lakh loan, and then you have already repaid by way of say 90,000, and then says for the next 3 months the interest accumulates is say about say 3,000. So your principal outstanding is going to become 93,000.
Right. This applies to employees. This applies to employees who are going to continue their employment. What about employees who are being laid off and who have to search for other employment? So there is a good 6 to 9 months gap by which they're going to get another job. So what happens during that period if they're not able to pay the loan? What difference can such people take?
There is nothing. You have to go and negotiate with the bank, ask for a restructuring and all of that, but there is nothing else. So government may extend this 3 month period, but if you need a 6 months, I don't know if government will extend or not, but there is
the status is not dependent upon whether you are an employee or not. It is your status is based on whether you are a borrower to a bank.
Right.
Yeah.
Yeah.
So you're saying that beyond these 3 months, the borrower will not be left with much options rather than to go back to the bank and restructure the loan.
Correct.
Yeah, and see what does the bank do.
Okay, there's one more person. AI. I hope this is not Zoom bombing. Let's try our luck. Yes.
Hi, good afternoon. I'm sorry for my name put out there. It just got there by mistake. So I have a few conceptual questions basically. So the first being, for example, in a hypothetical situation where the ban, as we know right now, that wasn't applied, but the government had issued some advisory directives, right? So in case a company took on advisory directives and didn't function, and that following those advisory directives led to the contract not being able to function, or them not being able to perform all the contractual obligations, is that going to count as a force majeure in the absence? I'm talking in the presence of a force majeure clause in the contract. Is that going to count as a force majeure situation in the eyes of the court?
No. You're saying advisory. Which advisory are we referring to?
Like the ministries had advised companies to not function in their offices, work from home, etc., etc. Now, because of any government advisory in any situation, if it's not a compulsion, if it's just an advisory, will that count as a reason for the force majeure? Or does it have to be a complete ban that you didn't have an option at all?
Okay, so what you're saying is that I took the advisory of the government to work from home, and hence there was a delay in my performance.
Right.
Okay. Then you should have intimated your counterparty before doing it.
Yeah, I did that. I intimated my counterparty, but my counterparty
how would you are saying it's a hypothetical situation.
I'm saying it's a hypothetical situation. I'm saying that my counterparty now is saying it wasn't, you weren't forced. It was an advisory. You didn't have a complete genetic ban on you. So if you chose to, you could have still done it, but you chose not to. So that's not a force majeure.
So it is understandable. It is understandable that the other party will contest it. It is understandable, but it will.
Yeah, you will be making us richer, AI.
Yeah. So when you go to the court, I'm sure courts will take a very positive. I mean, I really don't think the advisories. Somebody followed an advisory, so it will get the benefit. I'm pretty sure. I mean, anyway, that remains to be decided by courts, right? But
I just want to know something that's a completely hypothetical situation, but it just came up in my mind, so I wanted to ask that. I have just one other question, if that's possible.
One more question. Okay, go ahead.
So basically, sir mentioned.
No, it's not hypothetical. I'm fine.
Okay. So sir mentioned that not having money for raw materials was never a valid point for force majeure. But in the current circumstances, where the companies are not going to have money for 100 different reasons, it's going to probably now be counted as a valid reason for not being able to buy raw materials, not having the money to do so. And
we need to test it. We need to test it,
but you can, I mean, it is a prudent position to take right now, saying that
you are entitled. Courts do not discourage parties from taking a position that they want.
Okay.
It will, but at the end, it will adjudicate based on a given set of legal rules, principles.
Okay. Thank you so much. That was my question. Thank you.
Okay, Anuva, I will take Anuva. She has one more question. Anuva, go ahead.
Yes. Hi, Ramanujam. Hi, sir.
Hi.
I I have a real present day problem with me, where my client is a VP in a company, and
Okay.
she has not been paid since November 2019 her salaries.
Wow. Okay.
Now, this
It
company
has got nothing to do with COVID-19.
No, sir. But now that the company has written to her that we have suspended all our operations, they provide some kind of solutions to the malls. So the malls have written to them that there is a suspension of service for the month of April and May. So when the malls wrote it to the company also wrote it to its employees that there will be suspension of any kind of activity in the company for the month of April and May. But there's no clarity on what will happen to the salaries and other things. So though my client is a vice president in the company, she also does not have any idea, though her juniors are asking her, ma'am, what is the situation and what we should do. And then some junior employees told that they have been told by HR verbally that there will not be any salary and it will be like a leave without pay. Now they are not paying her salaries, saying that since the company is undergoing this kind of situation, we will not be able to pay salaries to the higher management also. So what can my client do in this situation? Actually, she wants to leave this company. She doesn't want to work here anymore.
Ask her to do it, no.
So then what about the salary since November? Because
No,
this will not come under any force majeure or anything.
If the company is not bankrupt, then surely you can, you'll be able to claim it from the usual money recovery channel.
You are any case as this thing, if you're it's under a contract of employment.
Right.
So under a contract of employment, being a white collar employee, you have remedies under the law. You are eligible to based on the pecuniary jurisdiction. Please approach the relevant
civil court. Yeah.
Because in any case now with the IBC having been amended from 1 lakh to 1 crore, it becomes very difficult for employees to reach approach NCLT. We are in fact on our website. You would see on our website you will see a blog on this as to how this has become difficult for employees to approach NCLT because of the change.
Right.
So this is where it's a real and present problem, Anubha. But yes, like the humanitarian angle is there from a employee perspective, and the bankruptcy or not, but the business continuity angle is there from the employer perspective. So this is a very, very tough time that all of us are facing. So as lawyers, it's a very interesting proposition that keeps coming to us. But we'll have to see if there's a legislation which comes in, we'll have to see how it works.
Yeah, I was speaking to some lawyers actually. So they were saying that maybe it will be rolled back, this amendment which has come in IBC. It cannot survive. 1 crore is not the right threshold. So
I agree with you. I agree with that perspective on the threshold perspective. Whether it will get rolled back and not get rolled back, it will become my answer. Any answer that I give is an astrological answer and not a answer based on a fact, information that I possess.
Right. Thank you so much.
Thank you so much.
Great. Thank you. There's Gaurav still wants to ask a question. Let's take quickly the second question. Gaurav.
Hello.
Yes.
Sir.
Gaurav,
My question is that suppose in a force majeure clause we have mentioned 30 days. Let's say 30 days time is to be given for a notice to be served.
Given for what?
For notice to be given if you are invoking force majeure clause, right? Okay. And for that particular,
does it say that you have to give notice of invocation within a period of 30 days from the time?
No, I think you have to tell the other person that you have 30 days to comply, or what is it? 30 days notice.
30.
What?
You have to. I'm invoking force majeure clause, and you have a 30 days time period for that notice to be issued.
For informing, that's a
for informing, right?
And for that particular force majeure, but that force majeure event has happened, you have a period of 30 days.
Right, for informing, for basically for
Excellent.
informing, right?
Excellent.
And that 30 days the post office is closed. Then what happens? I mean, that is already been passed because of the closure of the
Already
post office.
discussed this, Gaurav. We already
No,
discussed this.
we discussed without any time clause.
It
If
doesn't
we have
matter.
Answer
Time
remains
clause
the
won't
same.
change
My
anything.
answer remains the same, Gaurav.
all
Have
right,
you
all right.
intimated by email or not?
No, there is no mention of any email, and the client doesn't have an email also
Uh-huh.
because he's a contractor of a
Then
civil.
then call up, keep a recording of the call, send SMS, WhatsApp message,
All right,
whatever, something will, right? Keep proof.
Act in good
of it.
faith. Act in good faith. That's all.
fine,
Don't
fine,
go by.
fine.
Don't go by the letter of the contract. Act in
So
good faith. It will help you later.
really matter in this case, right?
Okay, so let's move on. There's more questions still coming in, but but I'm afraid we need to wrap up the session now. It is already 40 minutes past time. So
Yeah. Okay, we should.
yeah. So sorry, there are more questions I can see, but I'm going to end the session here. Thank you everybody for joining, and most of all, thank you, sir, very much for patiently answering so many questions.
My pleasure, Ramanuj. Thank you everybody for joining in. And
yeah, we thoroughly enjoyed the session. I thoroughly enjoyed the session, learned so much. Hope to have you again sometimes in another webinar. Thank you very much.
Thank you so much. Yeah, thank you.